Hi, I'm Mike Kalish, the Social Security lawyer, and in today's video I want to talk about step 5 of the 5-step sequential evaluation process. That's the process that Social Security uses to determine whether or not an individual who has applied for disability benefits meets Social Security's definition of what it means to be disabled. All right? And the easiest way for me to get this concept across is to describe this process as essentially 5 questions that Social Security needs to have answered to determine whether or not they're going to pay somebody their disability benefits. And these questions are sequential, meaning that we have to answer question number 1 before we go to question number 2. We have to answer question number 2 before we go to 3, etc., etc. To recap a little bit before we get into step 5, or the 5th question, we have to understand that each question, an individual can lose their claim at each step in the process. There's actually only 2 places, two points in this process where an individual can be awarded disability benefits or win their claim. That's at step 3, which is to meet or equal a listing, and at step 5, which is what we're going to talk about today. All right. But before we get into that, let me just do a quick recap of the 5 steps, the 5 questions. Question number 1 that Social Security needs to have answered is an individual who's applying for disability benefits, is that individual in fact working? Because if a person is working and earning over about $1,180 per month, and they're not blind, then in that situation, they are simply by definition not disabled. And it doesn't matter how bad their medical conditions are, it doesn't matter how severe how many medical problems they have, how severe they are. If a person is able to work, hold down a job, and earn gross over $1,180 a month, they simply are not disabled. Okay? So question number 1, is a person working? If the answer is yes, they're working and they're making over that $1,180 a month, they're not disabled. That's the answer. Then they're going to deny the claim. If the answer is no, they're not working, or if they are working, it's a pretty small amount, it's under that $1,180 gross per month amount, then we go on to step 2, and that is, do we have a medically determinable impairment that has already lasted 12 months, or is expected to last 12 months, or is terminal, and is severe? Now, that's a lot of verbiage in there, and to unpack all of that, if you don't understand what that's about, go back and take a look at my video talking about step 2 of the 5-step process. Essentially, again, the way I kind of paraphrase it, if you will, is are you seeing a doctor? Do you have current medical treatment? Are there medical records documenting your medical condition? All right, x-rays, MRIs, psychiatric testing. You have to have these formal tests done. There have to be what they call laboratory findings. There have to be signs. You cannot win a case by walking into the hearing office or walking into Social Security and saying my back hurts with nothing to support that. You got to have medical records. It's required by law. If you have questions about that, go back and take a look at video number 2 on the 2nd stage. Assuming that an individual, again, is not working, they are seeing a doctor and they have medical records, we go to step 3. And step 3 is, do you meet or equal a listing? I'm really not going to get into that right now. Essentially, if you have questions about that, go back and take a look at video 3. It talks about what that means and how to qualify at that point. Assuming that an individual does not meet or equal a listing, we then go on to steps 4 and steps 5. As I explained before, though, there's sort of an intermediary step between 3 and 4 where at that point Social Security needs to make an assessment of what an individual can still do despite their limitations. In particular, how long can you stand, how long can you sit, how much can you lift, how is your concentration, your focus, those kinds of questions. They put all that together into something that's called a residual functional capability, or an RFC, and then they go back and say, all right, we're going to take that RFC and see if with all of those limitations, could the person who's applying for disability benefits, could they still do the easiest job they did in the past 15 years? That's step 4. If the answer is no, They can't do their old job anymore. Their medical problems are interfering with their ability to do their old job. Then we go to step 5, which is the final step in the process. And that question is, okay, given an individual's age, education, vocational background, and their RFC, what they can still do despite their medical problems, is there any job that such a person could do on a full-time basis, either in the local economy where they're living at, or is there any jobs available nationally? All right. At this step, age does become very critical in the evaluation process. Social Security recognizes that as an individual gets older, it gets more difficult to transition to other types of work. So, for example, age 50 is a big milestone for Social Security. Age 55 is a big milestone. And sometimes you'll hear, well, not sometimes, all the time you'll hear the lawyers in this area of law, Social Security disability law, they'll talk about something called meeting a grid or a grid rule. Judges oftentimes will ask the attorney at a hearing, attorney, are you going to make a grid argument for your client? So what they're talking about are some rules that Social Security has that allow an individual, an older individual, to be able to qualify for disability benefits that whereas an individual, a younger individual, may not. Okay, the exact same facts and circumstances. The only difference between the two is the age of the person applying. Right? The grid rules are a little complicated. I'm not going to spend a lot of time talking about it. Just understand the basic idea with the grid rules. If you hear that term, what they're talking about are these rules that Social Security has that they will apply depending on the individual's age. All right. The grid rules apply to everybody, but the way they're set up, they're set up in such a way that as a person gets older, it gets easier to qualify for disability benefits. So what we're looking at step 5 is, well, okay, is there any other job that a person could do? And again, the way the judge at the hearing will try to make this assessment is they'll have that vocation expert present at the hearing, and they'll propose some hypothetical questions to the vocation expert based on the evidence that's in the record. And these hypothetical questions can sound very formal, and they're somewhat confusing if you're not sure what the judge is asking, if you're not used to it. And based on the answers to the hypothetical questions, the judge will determine whether or not an individual meets the definition of disability. So, for example, I think examples are always great because I think they make concrete what are very abstract ideas. So let me try to give you an example of this. So we have an individual, we're at step 5. It's already been determined, we're at the hearing. The vocation expert has already testified and said, no, this person, with the limitations that this person has, in particular how long this individual can stand, how long she can sit, how much she can lift, she just can't do her old job anymore. So now the judge is going to try to find another job for her, and he'll propose some hypotheticals. And where does he get these hypotheticals from? Well, these hypotheticals come out of the medical records that have been developed. So as the case had progressed through the different stages, at the initial application level, at the reconsideration level, behind the scenes, as the case is evaluated, the evaluators at Social Security have made assessments based on their review of the medical records. They look at the records that they have and they say, well, okay, we agree she probably, she's got degenerative back disease, she's had surgery, so we agree that she can't be on her feet all day, so we don't think she could do her old job as a waitress because that would require her to be on her feet all day and she'd have to lift, up to 50 pounds occasionally, and that we agree from the medical records is not going to happen. But we don't see any limitations on sitting, right? There's no reason why she couldn't sit. So we're going to deny the claim because we think she can do some kind of sit-down type of job. She could answer a phone for a law firm. She could, stuff envelopes. She could be a ticket taker at a movie theater. They're going to look for, at step 5, some other type of job that an individual, even with the problems that they have, they still could do on a full-time basis. So the key here is to essentially get the individual to prove to the judge. What we have to do at step 5 is prove that now you can't even do these very simple type of jobs, right? So again, it goes back to the records, it goes back to statements from what the doctors, hopefully supporting statements from the doctors, and it goes back to the testimony that the claimant made at the hearing. And so the judge will, based on all of that, will form his or her hypotheticals based on the information. So if Social Security said, well, we think she can still do a sit-down type of job, the judge will propose a hypothetical to the vocational saying, well, please assume an individual of the claimant's age, education, vocational background. Now assume that this person could only stand 4 out of 8 hours of the day, but she could sit for 6 out of 8 hours with normal breaks. She could lift up to 10 pounds frequently. If those were the only limitations that such a person had, would they be able to do any other type of job full time? And the vocation expert will look through her book and she'll say, oh yes, this person with just those limitations, such a person could be a ticket taker at a movie theater. Such a person could answer a phone for a law firm, right? And because there are other jobs available that such a person with those limitations could still do, the judge is then going to say, okay, I'm going to deny the claim because there's other jobs you can still do. If, however, the hypothetical says something like, well, no, I'll give you an example, would be like, all right, now same individual, but now instead of being able to sit for 6 hours out of an 8-hour day with normal breaks, this person could only sit for a total of 4 hours out of an 8-hour day with normal breaks. Stand only 4 hours, sit for only 4 hours total out of an 8-hour day. Either stand or sit, the max she could do would be 4 hours out of an 8-hour day. She could lift up to 10 pounds frequently. Now, with those limitations, would there be any type of full-time competitive work that such a person could do? Vocation expert is going to come back and say, no, Judge, there isn't, because what you're telling me is that she can only stand 4 hours out of the 8-hour day, and she can only sit for 4 hours of the 8-hour day, and that's total. In other words, she couldn't do half the day standing and half the day sitting. Regardless of sitting or standing, the most she could do would be 4 hours. Well, by definition, 4 hours is less than full-time work. So no, there is not going to be any job out there. So, and the judge will then, hopefully, if he accepts that testimony from the vocational expert, the judge will then find the claimant disabled. So it's a little complicated, I know. It's a little confusing how they do this process, but essentially step 5 is about, well, given her age, given her background, her work history, her vocational history, given her education, given the types of jobs she's done in the past, the skill sets that she's learned at those jobs, would there be any other jobs out there in significant numbers? They can't just find one job someplace for you. They have to find a certain number of jobs that would be available. Are there jobs out there that a person could still do on a full-time basis? If the answer is yes, there are, then again, the claim will be denied. They're going to say, all right, well, she needs to go out and get one of those jobs. If the answer is no, there are no jobs like that, Judge, then the judge, assuming that the judge accepts the testimony from the vocation expert, will then find that the claimant is disabled and award the benefits. So again, to recap, I said at the beginning, there's 2 places in this process, this 5-step process, at which a person can be awarded disability benefits. They can be awarded disability benefits by meeting or equaling a listing at step 3, and they can be awarded their disability benefits at step 5 when there's no other work that can be found for a person with the limitations of record. So again, that's how it works, and they have this very formal framework. The reason they use this very formal framework is out of a concern, a requirement that everybody gets treated the same. If you have questions about this, I know it is complicated, it's nuanced. I've tried to give down the simplified, paraphrased version. There's a lot of things that I've left out in the analysis. I've done that on purpose so as not to overload people with information. But if you have questions and or concerns, please take a look at my website. I discuss it further in detail there. Alternatively, you are more than welcome to call my office. I'm happy to talk to anybody about these issues. My phone number here in Southern California is 714-548-3292. Again, 714-548-3292. You can also find me on the web at www.thesocialsecuritylawyer.org. Thanks for watching. I hope you found these videos helpful.